All right, great. I think they will probably be still admitting some folks into the lobby, but from the lobby, but I'll just go ahead and get started. Welcome and thank you so much for joining the second of our listening sessions dedicated to the intersection of privacy, equity, and civil rights. I am Travis Hall with the National Telecommunication Information Administration, part of the Department of Commerce, and I use he, him pronouns. NTIA has been engaged in questions of surrounding privacy policy for quite a while now, including the 2012 Consumer Bill of Rights and the 2015 draft legislation, companion draft legislation, and the 2018 request for comment. Today's session will be focusing on questions around structural inequity and the ways in which commercial data flows play a role in that, both in terms of cementing or ratifying or recreating those inequities, but also possibly ways to alleviate those inequities. So we're going to be starting off with a keynote by Professor Latonya Sweeney. Latonya Sweeney is a professor of practice in government and technology at Harvard University, where she's a founder and director of both the Public Internet's Tech Lab and of Data the Privacy Lab. And we're going to then have a keynote from Jennifer Urban, the chair of the California Privacy Protection Agency Board and clinical professor of law at the University of California, Berkeley School of Law, where she's director of policy initiatives at Samuelson Law, Technology and Public Policy Clinic. And then we're going to have a panel of experts in privacy, civil rights, and advocacy on these issues, who will provide a factual foundation for the conversation, as well as provide some helpful framing and insights into the role that privacy plays in questions of equity. And then that will be followed by a chance to hear from all of you. This is a listening session. We are here to listen. We are here to hear from all of you. And we will be looking forward to that. And that will immediately be following our expert panel. So without further ado, let me introduce Professor Sweeney. Professor Sweeney, if you'd like to go ahead and go on your camera and go off mute, welcome and thank you so much for joining us.
Well, thank you. And it's a pleasure to be here and help kick off the event. I want to focus, hopefully it's working. Okay. I want to focus primarily on the question of how technology has literally become the new policymaker. And therefore,
Professor Sweeney, I apologize for interrupting. If you could close that one window there
of
the chat.
In the middle can you see it now?
That's
okay.
Perfect. Thank you.
All right. All right. Great. Yeah, how technology design is sort of the new policymaker, and how do policymakers rein it back in? Just to set the stage, I'm going to go back for a while. This is what a camera looked like at the time American jurisprudence was trying to figure out what were going to be the rules to photograph people in public. And the decision, after some wrangling in courts and so forth, turned out that the decision is you can photograph people in public without their permission. And this is what a telephone looked like at the time American jurisprudence was going to determine what were going to be the rules for recording phone conversations. And the answer turned out to be you need consent to record phone conversations. And then in 1983, this thing came to market. And of course, my students have no idea what it is. But for those of us who are older, this is the Sony Camcorder. It was the first device for consumers that ran on batteries that recorded both video and sound. And immediately, it was a bit of a success. But as soon as you look at it, you say, man, that thing is clunky and big. The manager in charge of the product, Minoru Morio, also felt it was too big. So he calls in his lead engineer. He says, look, you've got 18 months. I want something that will fit in the palm of my hand. And so they worked, and this was no small feat because they had to invent tons of parts. It wasn't just a matter of miniaturizing it. They had to solve current problems, else it would be too hot. And they missed the 18-month deadline, but 2 months after that, out came this Sony Handycam. And sure enough, in their advertising, they show it fitting in the palm of a hand. And of course, it's a technology. and it rained money on them, millions and millions of dollars. We couldn't keep them on the shelves in the United States or anywhere else. But it had an interesting technology design. It had no mute button. That meant it was impossible to record video without also recording sound. And as you can predict, people went to jail. There was a mother who strapped one of those to her child on a Pennsylvania school bus, and it captured atrocities from the school bus driver and the teacher towards the child. She takes the video down to the police station, and they arrest her for illegal wiretapping. There's the case of the Boston protester that was being arrested. A bystander on the sidewalk pulls out one and begins recording the arrest. The police stop arresting the protester and they arrest the bystander instead. And he faced 7 years in prison. Now we fast forward to today. The ACLU took that case at the protest and others that want us the right to record the police in the service of their public duties. And Pennsylvania has a law that every school bus must record both video and sound. So what's interesting about this example is here an arbitrary design decision and a technology, in this case, the lack of a mute button, ended up with us changing our laws, ended up with people going to jail in the interim or facing jail time in the interim. And the other thing that's interesting about it is when something's successful in the marketplace, its design gets replicated without question. So today, if you or I wanted to record a video, we don't reach for our camcorder, we pretty much reach for our mobile phone. And our mobile phone also doesn't have a mute button, even though it would just simply be a software update. I use this as an example of many of the themes that we'll keep coming back to in our few minutes here talking together. But the first of those themes is that technology designers are the new policymakers. We don't vote for them, we don't elect them, we don't even know their names, but the arbitrary decisions they make in the design of the technology they create dictate the rules we live by, determine whether or not our laws can be enforced or not. And so for this reason, I do introduce a new term, a new kind of technocracy, where the design of the technology determines how to control or govern our society. So my history is an interesting one. Over the last few decades, couple of decades, I've had the uncanny history of being early to a problem, doing a simple experiment that shows the issue itself, sort of lays it bare, if you will, and then having 1,000 great minds follow. The first time this was to happen was in 1996 when I was a graduate student in computer science at MIT, and I got engaged in a conversation with an ethicist who foretold the future about social contracts being broken by, at that time, the big technology was the simple of hard drive storage, how much disk storage people could have, and the ability to share data widely. Eventually, the conversation moved to a health data set. That health data set didn't have any name or address in it. It had diagnosis, procedures, that kind of thing, the things you see in that left circle over there. And the only information it had about any patient was their month, day, and year of birth, their gender, and their 5-digit zip code. We got in a bit of an argument, and the question was this data anonymous? William Weld was the governor of Massachusetts at that time, and he had recently collapsed, so information about his health data, his health information was in there. So for $20, I went down to City Cambridge Hall and got the voter list it came on 2 5¼ inch floppies, something that my students also don't know what I'm talking about with 5¼ inch floppies. They say they remember them with hard cases. But anyway, the point is that the voter file, which is also public information, had voting information, but it shared those same demographics. The question is, how unique would those demographics be? 6 people had his date of birth, only 3 of them were men, and he was the only one in his 5-digit zip code. Those characteristics were unique for William Weld. And then after that, I ran an experiment across the 1990 census data and showed that about 87% of the people in the United States were unique based on those simple demographics. It was an interesting time. Literally a month later, I ended up testifying because at that moment in time, Congress was debating what was become known as the Hipaa privacy rule. And that simple experiment exposed a problem that wasn't even it wasn't just in the United States, but it was a problem around the world, because that was the best practice used. That is, you remove the explicit identifiers and you can leave the demographics. And what that simple experiment showed was that that was no longer okay in the light of the current technology, the rise of disk storage space. And so Hipaa and laws around the world changed as a result, and many of them cite that experiment. And of course, it launched this field that we have in technology and computer science called data privacy. That year was 1996. Where are we now? A few years ago, we tracked all the places a typical patient's information might go. The dashed line is de-identified, and the solid lines is where the person is explicitly identified. And one of the interesting things about it is only half the flows are covered by Hipaa. The other half aren't covered by any regulation at all. It's whatever it goes, and whatever goes between the parties sharing the information. Notice also that most of the sharing, the person isn't even a party to, would have no way of knowing it, even though the person could be harmed. Information, if you look at some of the cycles that come back to their employer and so forth. The point is that that trajectory started in 1996, but even today, data privacy is up for grabs. Up for grabs by what technology design allows or doesn't allow. If a new technology comes out and it has privacy built in, we get it. If it doesn't, we don't. The next time something like this was to happen was going to be years later, when I became a professor here at Harvard. And I was being interviewed with a reporter, and I wanted to show him a paper. So I typed my name into the Google search bar, and the link for the paper came up, and he said that he wasn't interested in the link for the paper. What he wanted to know was about the time I had been arrested. And I said, well, I haven't been arrested. And he says, then why does your computer say you have? He focused on an ad that implied I had an arrest record. We spent a while there talking, and eventually we started learning and figuring out that the ads only pop up if there's a first and last name of a real person. You had to have both of those names together. And that if your name, like versions of Latonya, they came up with these arrest ads. Other names came up with just neutral ads, like find more information. So the reporter was an Italian American, and he says, oh, I get it. It's because you got one of those black sounding first names. And I said, look at him. What do you mean black sounding first name? What do you know about a black sounding first name? But then I typed Latonya into the Google search bar, and up popped all these black faces. And I typed Tanya into the Google search bar, and up popped all these white faces. And it becomes really clear, something that we were able to document in data and had actually been documented even before then, that there are some names given more often to black babies than white babies. But the question was, why was this algorithm discriminating against them, distinguishing, and providing arrest ads in one case and not in the other? So I did a large experiment, about 142,000 lookups of VPNs around the country. And these ads popped up even in cases where the person who was getting an arrest ad had no arrest record, and people who never got arrest ads had in their database actually did have an arrest ad. So why is this important? Because discrimination in the United States is not illegal. In fact, as my hair keeps getting grayer, I'm looking forward to my senior citizen discounts, and my students, of course, enjoy their student discounts. But what is illegal in the United States is some groups under certain circumstances. One of those groups is blacks, and one of those circumstances is employment. And so if Ebony and Jill here are both in competition for the same job, and an employer types their name into Google, Ebony's placed at a disadvantage if arrest ads only come up on her name and not on Jill. And you know, a little discrepancy for a few people is one thing. The question is, how many people are impacted? The study showed that if your name is given more often to black babies than white babies, you are 80% more likely to get an ad implying you had an arrest record, even if you didn't. So this became the first example of an algorithm sort of qualifying that's the standard that the Department of Justice used, the 4/5 rule, for an investigation under the U.S. Civil Rights Act. It also launched the whole issue of algorithmic fairness among computer scientists as an area of study. So why did this happen? How come? Well, if we assume that the technology is just so mathematics, kind of neutral in its origin, that it was represented here by the peach box, the question is, what's going on? So it could be the case on the left-hand side, it had to have some data, some setup data, in order to deliver ads. The advertiser had to give ad text, copy text that would appear. And maybe that's where the bias was. Maybe the advertiser's only providing that kind of text in that situation. The other thing that's interesting is the algorithm is trying to optimize Google's income. And so it doesn't know which version of the ad copy is going to make the most money for it. So as a result, the more people click on it, the more it will bias towards the one that's giving it money. And so it could be that this was a reflection of society. But the most important thing is the only reason we even know this happened is because we were able to measure the adverse impact. And either way, the US Civil Rights Act is up for grabs. I'll just use a couple more examples. Time is tight and there's so much to cover with you today, but let me just give you a few more examples. This is an example that Alvaro Bedoya and I used to do together. The idea here is just before, nowadays there are several companies that actually do this. Back then, none of them did. But basically you have a company who has a ton of resumes and they offer a new service to employers that says, we'll use that are interesting to you, of interest to you. So the employer says, I'll take these three, but not these three. And over time, the algorithm begins to learn the preferences of the employer, which in this case is a preference towards youth. This time, though, it's the external interactions with the employer and the algorithm that's causing it. And we're not a party to it, so we don't have any mechanism to observe the adverse impact. So then, what is the future of the Equal Employment Act if it can't even be, if the evidence for it can't be gathered or provided? In the interest of time, I think many of you have heard about the recidivism algorithms. These are algorithms in criminal justice settings that have been used to make all types of recommendations. This is an example where a juvenile who stole a bicycle versus an attempted robbery, armed robbery, the scores are dramatically different. And one of that reason is that they're more a reflection of the prior decisions judges made. But instead of being packaged as a result of the prior decisions judges made and the bias there, it comes from an algorithm that looks neutral, that has mathematics behind it. It makes us believe that it itself is neutral when it isn't. Either way, it means criminal justice is up for grabs. I'll use this as my last example and then try not to end on a depressing thought. This is Joy Bowani when she was a graduate student at MIT. And the image on the left, what she's doing is she's looking into the camera of her laptop. And the program that's looking back is a face detection algorithm, only it doesn't see her face. It doesn't see her face until she puts a white mask in front of it. And then we see the active appearance model triangulating to identify her eyes, her nose, her mouth. Her work went on to show that face recognition, which is also based on this same technology, had the bias that it does not work well with darker skinned people or with women versus men. And of course, the worst would be dark skinned women. And that also is a bias from training data over decades of primarily having competitions that were primarily white male faces. These examples show us that every value is up for grabs by what technology design allows or doesn't allow. Now I'm going to skip ahead so that we don't land on a sad thought. In 2016, we were the first to find those bots on Twitter, the first to find problems with voter registration websites. But I want us to end this discussion on, so what do we do about it? So I spent some time as the Chief Technology Officer at the Federal Trade Commission. And when I came back, I realized that my history had been one of simple experiments that were illuminating and allowed the laws and those who would protect us to protect us. Could I teach students to do the same? And over the and since I left the Federal Trade Commission, we've been doing exactly that. Students were the first to point out price discrimination in online Princeton review. Our students were the first to get Facebook to stop putting GPS locations inside of Facebook Messenger, something the industry had not been able to get Facebook to do for 2 years. Our students were able to do it within a week. Airbnb, when students showed them how hosts of different races weren't making the same amount of money, Airbnb changed its platform, setting the price so that today people can go on and not have, and hosts don't have that discrimination. We've shown how submissions into public comment servers can be biased by deepfakes that cannot be detected by humans, and government groups have been trying to come up with remedies for that. And our most recent finding is Facebook's algorithm continues to discriminate by race and ethnicity when advertising. That is, I can choose a race and then target algorithm or misinformation directly to that race or that ethnicity. So these kinds of works have been really powerful. We've also launched a couple of platforms. The thing about this talk is that on the one hand, I say we live in a technocracy, every value is up for grabs. There are things we can try to do and are trying to do to change the way we train technologists so that they can put more protections in the technology they build. But by the time it goes through the life cycle and goes to commercialization and comes into the marketplace, it's bundled in a business package. And it forces regulators to have to learn how to enforce old practices and old rules on new technology. So this talk really isn't about me or my students. This talk is really about you and how you can save the world. Thank you.
Thank you so much, Professor Sweeney. No pressure. We greatly appreciate the insights and the history and all of the wealth of your expertise. Thank you so much. Next up, we have Jennifer Urban, who is a clinical professor of law at the University of California, Berkeley School of Law, where she's director of policy initiatives at the Samuelson Law, Technology, and Public Policy Clinic. She was appointed by California Governor Gavin Newsom in March 2021 to the inaugural chair of the California Privacy Protection Agency Board. And of course, the California Privacy Protection Agency was created by the California Privacy Rights Act of 2020 and is charged with implementing and enforcing the California Consumer Privacy Act of 2018. And with that, let me pass it over to Professor Urban and Chair Urban. Thank you so much.
Thank you, Dr. Hall. Thank you also to Lindsay Barrett and all the team at NTIA for inviting me and organizing this important listening session. As Dr. Hall said, my name is Jennifer Urban, and I'm a professor at the University of California, Berkeley. In March, I was appointed by Governor Gavin Newsom to chair the board of the new California Privacy Protection Agency. I'm delighted to be here today. I do need to make clear that I'm not speaking on behalf of the California Privacy Protection Agency, its board, or the University of California, or any of my clinic clients. I'm particularly grateful to be here because NTIA, through these listening sessions and its planned requests for comment and other efforts, is recognizing the broad impact of data use on the lives of all Americans, and especially its harmful potential effects on communities who experience marginalization or disadvantage. As this listening session and all of the experts participating and have underscored, the collection and use of information about people can have profound effects. What is discussed as privacy and data protection, and more recently, algorithmic accountability, thus can tie directly to issues of discrimination and harm. I'm going to talk today about the approach California is taking to protect Californians' data. I will offer some background about California's approach. I realize that some of you in the audience will be quite familiar with it, so please bear with me for those who are not, and then discuss some of its potential for addressing inequities arising from data processing. So first, some context and background. California has a tradition of data privacy protection. California's state constitution explicitly protects the privacy of California citizens, and California has steadily developed privacy protections over the years. For example, in 2003, California enacted the first data breach notification law in the US, and over the years has followed with protections for information such as electricity data, student data, and data held by data brokers, among other things. In 2018, California passed the nation's first comprehensive data privacy law, the California Consumer Privacy Act of 2018, known as the CCPA. This law was passed by the legislature. As Dr. Hall mentioned, last year, California voters directly amended and extended the CCPA with a ballot initiative, Proposition 204, the California Privacy Rights Act, or CPRA. With the CPRA, voters expanded Californians' rights to control the use of their personal information by businesses and established a new agency, of which I am chair of the board. The CCPA and the CPRA give Californians new rights to control their personal information and give businesses new responsibilities for the personal information of California residents that they collect and process. The California laws update the previous, in my personal view, inadequate notice and choice regime in a variety of ways. California's new laws still, for the most part, create an individual-focused regime. Consumers need to opt out. But the law is designed to make it much easier for consumers to understand what choices there are and includes a number of requirements to make it more practical to exercise them. First, the law places obligations on covered businesses to provide meaningful and actionable notice to consumers. The law requires businesses to provide specific and clear information about who is collecting consumers' personal information, for what purposes, how long it is being kept, how it is being used, and to whom it is disclosed. The California Attorney General in 2020 promulgated regulations under the CCPA that provide businesses with even clearer guidance for notices. Second, the new law gives consumers important rights to understand and control the use of their personal information, rather than simply expecting them to choose another business if they don't like a business's data practices. Under the law, consumers can request access to their personal information held by businesses. On request, businesses must provide the categories and the specific pieces of information the business has about the consumer, the purposes for which the information is being used or shared, and information about third-party businesses with whom the information is being shared. Consumers also have the right to have businesses delete their personal information. And under the CPRA, as it takes effect over time, they will have the right to request the correction of inaccurate information. The laws also give consumers choices about how their personal information is used. Consumers have the right at any time to opt out of the selling or sharing of their personal information. This includes, for example, the right to opt out of the use of personal information for cross-context behavioral advertising, which the CPRA specifically defines. Opt-out options also must be easy to find and exercise. The Attorney General has included global opt-outs, such as a setting on a browser, in the regulations, and the CPRA explicitly calls for regulations to create standards for these opt-out preference signals that communicate consumers' rights. In addition, consumers can authorize others to exercise their rights for them. Both for-profit and non-profit organizations have begun providing this service. Businesses cannot retaliate or discriminate against consumers for exercising these rights, though they can offer certain limited financial incentives. Businesses are also prohibited from using deceptive methods, like misleading dark patterns, to persuade consumers. The California framework also buttresses the individual choice framework in several ways. For example, the CPRA adds purpose limitation and data minimization requirements. Under these requirements, businesses won't be able to collect more personal information than what is reasonably necessary and proportionate for the disclosed purposes for which it is being collected. And they won't be able to retain the personal information longer than is necessary to achieve those purposes. The CPRA also requires businesses to extend protections to their own service providers and contractors through contractual agreements. Both CCPA and some of the CPRA amendments intersect with the problems posed by these listening sessions, the inequitable and structural effects of data use. I will briefly discuss three relevant aspects of the law: the structure and reach of the CCPA as amended by the CPRA, the role of the new California Privacy Protection Agency, and enforcement. In its structure and scope, California's law moves beyond previous, more limited understandings of what kinds of data people should be able to control to a more realistic accounting of data use and its potential effects. For example, Dr. Sweeney, from whom we just heard, famously showed how information that was not personally identifiable under an older rubric still could be used to identify a person. Personal information under the CCPA therefore defines personal information as any information that identifies, relates to, describes, is reasonably capable of being associated with, or could be reasonably linked, directly or indirectly, with a particular consumer or household. The law includes a non-exclusive list of types of information. These do include familiar forms of personally identifiable information, such as a name, an address, or a driver's license number, but also broader forms, such as internet browsing, search history, and interactions with a website or advertisement. It also explicitly includes characteristics of classes of people protected under California law. These include, among other characteristics, race, color, ancestry, national origin, religion, sex, gender, sexual orientation, medical condition, genetic information, disability, and other characteristics. Under the CPRA, consumers will also have the right to impose additional limits on the use of their sensitive personal information, which includes, among other things, security-sensitive information like login credentials, the content of certain communications, and geolocation data. Sensitive personal information explicitly also includes information about a person's racial or ethnic background, religious beliefs, union membership, sex life or sexual orientation, and health and genetic data. Personal information in the eyes of the CCPA, then, includes some of the types of information that can be used, intentionally or not, to discriminate against and harm historically marginalized groups of people. Similarly, the CPRA amendments cover profiling, defined as any form of automated processing of personal information to evaluate certain personal aspects relating to a natural person, and in particular to analyze or predict aspects concerning that natural person's performance at work, economic situation, health, personal preferences, interests, reliability, behavior, location, or movements. By moving on from PII to a more complete understanding of how data about people is and can be used, the CCPA begins to offer more realistic tools to address and prevent harm. Profiling, for example, could, in my own view, encompass the example Dr. Sweeney just talked about with regards to certain names being interpreted to be tied potentially to arrest records, or the example discussed on yesterday's panel of a disabled person who took a medical leave being screened out of an automated job application process because the person's leave was interpreted as a gap in employment, and also the software predicts something negative from that about the person's job performance or reliability. The CPRA amendments also address algorithmic decision-making directly. The law directs the agency to issue regulations governing access and opt-out rights with respect to businesses' use of automated decision-making technology, including profiling, and requiring businesses' response to access requests from consumers. These responses are to include meaningful information about the logic involved in those decision-making processes, as well as a description of the likely outcome with respect to the consumer. The law will also require businesses whose processing of consumers' personal information presents a significant risk to privacy or security to perform annual independent cybersecurity audits and submit to the California Privacy Protection Agency risk assessments analyzing the processing of personal information. The agency also has independent audit authority. These transparency requirements are especially important because historically, inequitable and discriminatory effects have too often gone unnoticed by those outside affected communities. And as Dr. Sweeney pointed out, without looking, sometimes it's hard to see them at all. And therefore, they have been left unaddressed by enforcement agencies and by businesses themselves. The CCPA both encourages communication from consumers to businesses through opt-out and other requests, and puts in place transparency measures to give individuals, businesses, and enforcers information about data use and its effects. This brings me more directly to the role of the California Privacy Protection Agency specifically. In my view, one of the biggest innovations in the law is the creation of this new agency. The agency is modeled on data protection authorities in other countries and is the first agency with full administrative power focused on privacy in the United States. The agency's mission and basic charge is clear in the law. The law talks about consumers, but the charge explains that the agency is to protect the fundamental privacy rights of natural persons with respect to the use of their personal information. To this end, the agency is vested with authority to implement and enforce the CCPA and tasked with a wide range of responsibilities. The three most substantial are rulemaking, public awareness and guidance, and administrative enforcement. The agency is tasked with initial rulemaking, for example, related to the issues of profiling and algorithmic decision-making and opt-out mechanisms I mentioned by mid-2022. These efforts are currently underway. We've issued an invitation for comment as part of our preliminary efforts before the formal rulemaking. We're planning to have informational hearings or other workshops as a learning exercise and as give an opportunity for the public to publicly comment. And of course, we're planning the upcoming formal notice of proposed rulemaking. The agency is also explicitly tasked with supporting public awareness of the rights and responsibilities provided in the CCPA and with providing guidance to consumers and businesses. In its public meetings, the board has stressed that rights must be meaningfully available to all California communities. Both rulemaking and public awareness provide an opportunity, and in my own view, a responsibility to develop a more complete understanding of impacts on all California communities and to adopt a more complete approach than has historically been achieved. Yesterday's panel explained the crucial importance of involving affected communities in the development of impact assessments and rules. The agency will also be responsible for administrative enforcement of the law. It will begin its own administrative enforcement in 2023. In my personal view, enforcement of that effort should take into account the effect violations have on communities and seek to disincentivize activities that differentially negatively affect or disproportionately harm some communities. It's also useful to recognize that the agency's enforcement authority and responsibility will be shared with the California Attorney General, which will remain responsible for civil enforcement, and that the Attorney General can also enforce the full range of California laws, including civil rights and anti-discrimination laws. Businesses also have an important role to play. The law charges the agency with protecting Californians' privacy while giving attention to the impact on businesses. My own hope is that the agency's rulemaking and public awareness will create an opportunity for understanding by businesses of impacts they may not otherwise have known about and may not intend, and understanding by the agency and the public of how businesses are addressing privacy and related issues. My hope is for businesses to have a clear understanding of the public's needs and clear, balanced rules to follow, and for the public to have meaningful protections. Finally, I would like to say a word about harmonization and collaboration. The CCPA and CPRA's protections apply to any California resident, and their responsibilities apply to businesses that collect the data of California consumers, even if those businesses are not in the state of California. In addition, data flows across state and national borders, as we all know. Accordingly, the CPRA specifically charges the California Privacy Protection Agency with cooperating with other agencies with jurisdiction over privacy laws and with data processing authorities in California, other states, localities, and around the world. For this reason, I am particularly pleased and grateful to have been invited to talk today and to listen and learn as part of the NTIA's effort with its listening sessions. And I will very much look forward to NTIA's request for comment and further work in this area. And I hope that there will be participation in our rulemaking by some of the experts today, other experts who are watching, expert agencies like NTIA, and especially by those who live the law and the regulations every day, individuals, their communities, and the businesses responsible for their personal information. I hope everybody will keep an eye out for the agency's additional preliminary activities and for the NPRM, and that everyone will consider participating. It is important to communicate and learn from one another in order to protect the privacy and individual rights of all our citizens. Thank you very much, and we in California look forward to further discussion and collaboration.
Thank you so much, Chair Urban, for the insights that you've given to the process, to what you're thinking in California, and of course, the intersection with conversations around civil rights and equity. With that, we're going to be turning now to our panel. A few notes in terms of just some restating the ground rules. My name is Travis Hall. I am with the National Telecommunication Information Administration with he, him pronouns. These events are recorded. We will be subsequently making the recordings available on our NTIA's website along with a transcription. Live captioning is available through Teams, desktop, mobile, and web applications, but live captioning must be enabled by individual participants. And NTI staff will be monitoring the live chat, video, and audio, and we will remove participants who are attempting to disrupt the proceedings. And with that, let me turn it over to my colleague, Lindsay Barrett, who will be moderating our panel discussion. Thank you.
Hi, everybody. Thank you so much for joining us, and welcome to the panel discussion for day 2 of NTIA's listening sessions on the intersection of privacy, equity, and civil rights. I'm going to briefly introduce our esteemed panelists, and they will then have the chance to speak for 5 minutes each. We'll move on to Q&A after that, and if we have time, we'll take questions from the audience. Members of the audience, please put any questions that you have in chat or email them to my colleague, Travis Hall at hall@ntia.gov. All right. So we're going to start with introductions and then move on to letting our panelists speak for a bit, starting with Snigdha. Snigdha Sharma is team lead and tech equity analyst at the National Fair Housing's Tech Equity Initiative. Her interests and research lie in eliminating bias in algorithmic-based systems used in financial and housing services, increasing transparency and explainability for AI tools, outlining ethical standards for responsible tech, and advancing effective policies for regulating AI. Claudia Ruiz is a policy analyst at Unidas US. Unidas US is formerly the National Council of La Raza, the nation's largest Latino civil rights and advocacy organization. Working with cross-cutting civil rights issues ranging from voting rights to policing reform, digital equity, and algorithmic justice, Claudia advocates for policy reforms and civil rights protections that promote equity and inclusion for the Latino community. Karen Levy is an assistant professor in the Department for Information Science at Cornell University and associate member of the faculty at Cornell Law School. She teaches and writes about the legal, social, and ethical dimensions of artificial intelligence and other data-intensive technologies. Urmila Janardhan is a policy analyst at Upturn, which aims to advance equity and justice in the design, governance, and use of technology. They co-authored Upturn's recent reports on law enforcement use of mobile device forensic tools and the online hiring processes of large hourly employers. Scott Skinner-Thompson is an associate professor at Colorado Law School, where his research focuses on the way privacy can advance anti-subordination goals. He explores these themes in his new book, Privacy at the Margins. So with that, we're going to go in that order. So Snigdha, followed by Claudia, Karen, Urmila, and Scott. And everybody's going to talk for a bit, and then we'll move to Q&A. Thank you.
Thank you so much for the excellent introduction, Lindsay, and everybody at NTIA who made this panel possible. First, I'd like to briefly tell the audience about the National Fair Housing Alliance and its Tech Equity Initiative, and then we'll dive into how personal information could lead to disparate impact in AI-driven solutions. So the National Fair Housing Alliance is the country's only national civil rights organization dedicated solely to eliminating all forms of housing and lending discrimination and ensuring equal opportunities for all people. NAFA's Tech Equity Initiative is a multifaceted effort designed to eliminate bias in algorithmic-based systems used in housing and financial services, increase transparency and explainability for AI tools, outline ethical standards for auditable, responsible, and fair tech, advance effective and efficient policies for regulating AI tools without limiting innovation, and increasing diversity and inclusion in the tech field. The goal for our organization is to really have a gold standard of algorithmic fairness adopted by regulators, developers, and consumers of AI-based systems. On the issue of personal information and disparate impact in AI, many business decisions today, such as information search, product recommendation, interest rate determination, and housing and lending decisions, are driven by algorithmic systems such as statistical models, machine learning, and AI systems. As AI evolves, it magnifies the ability to use personal information in ways that can intrude on privacy interests by using obnoxious variables that may be proxies for personal data. For example, zip code is known to be a proxy for race and housing and AI, or machine learning solutions could use features that may proxy for zip code and thereby cause disparate impact injuries to housing or financial consumers. A predictive variable in machine learning algorithms may act as a statistical proxy for demographic characteristics if one, both the variable and the demographic characteristic are correlated with credit performance, and two, if all or part of the variable's ability to predict credit performance derive from its correlation with the demographic characteristic. For example, if it does not have predictive power independent of demographic status, or it has less predictive power once the predictive power attributable to demographic status has been factored out. In general, proxy testing or disparate impact testing in housing as it relates to personally identifiable information, PII, is not a trivial problem. And this is one of the reasons why regulators and policymakers need to scrutinize AI or machine learning solutions in housing and financial markets. Because of the underrepresentation problems in the data that fuel ML models, I think ML is going to drive, if not already driving, disparate treatment and disparate impact components of traditional fair lending testing from group comparisons to individual comparison. Machine learning developers will often use model performance to defend direct or indirect use of personal information. However, machine learning is showing that social and civil rights considerations are essential for defining alternative metrics for evaluating model performance. Gross manifestations of past injustices on racially marginalized and economically disadvantaged groups in model data suggest that accuracy is inadequate for measuring model performance. At the National Fair Housing Alliance, we are exploring the prohibition on the use of protected class information, which include personal information in housing decisions. We strongly recommend a reconsideration of the prohibition, at least for research purposes and pilot studies. Evidence on the usefulness of direct inclusion of protected classes in machine learning models is very scanty. A 2020 research article by Lee and Floridi considered limitations of mathematical fairness metrics and proposed a trade-off analysis approach, that is, accuracy versus fairness, to selecting a less discriminatory alternative model. They directly used race in their models and found models with and without race to have equal performance, and that models with and without race have equal trade-offs between accuracy and fairness. Given that protected classes were directly observed or inferred by human underwriters, and these human judgments contribute to the data that power these underwriting machine learning models, it may be imperative to allow direct use of protected class information to have apple-to-apple comparison between human and algorithmic underwriting decisions. The challenge is to pass privacy legislation that protects individuals against any adverse effects from the use of personal information in AI without unduly restricting technological innovation or ensnaring privacy legislation. Thank you.
Thank you so much, Snigdha. Claudia, could you jump in, please?
Sure. All right, here we go. We're here. All right, great. Can everybody hear me? I've been having tech problems. Sorry, this is great. All right. Well, again, what I want to start with is a sincere thanks to Lindsay, Travis, and the entire NTIA team for having these listening sessions. The amount that we can learn all from each other and as a collective is really sort of crucial within this space. So I really appreciate you guys getting this done, especially towards the end of the year. So my background, I'm a civil rights analyst at Unidos US, and so I actually come to Tech accountability and issues of algorithmic justice originally from a civil rights lens. My work portfolio includes issues such as anti-hate, criminal justice, and voting rights. And it is actually from each of those bodies of work that I kind of layer over this issue of tech accountability with an angle towards civil rights specifically. And I think that that's kind of the beauty of having gotten sort of new positioning within this sector, because of the ways in which we can learn a lot from sort of existing civil rights laws and the ways in which we've contended with unexpected harms that I think Professor Sweeney did a great job of highlighting at the top of the call, rather than having to rework an entire new framework to keep pace with these quickly evolving technologies. The intersectional and far-reaching harms that I think each and every one of my co-panelists will highlight, I think really does the best job of underscoring the importance of having strong anti-discrimination and civil rights protections for data collection, processing, usage, and minimization policies. Despite their variety, as you'll hear from each of us, these harms are united by what does unite these harms is the single undertow of a lack of consumer data privacy protections and enforcement. We hear a lot about the ways in which big tech players' business models drive many of the civil rights and liberties abuses associated with data-driven technologies within the digital economy. These have huge implications for both the consumer protection end of things and the competition side of the sector. But the core foundation of each of these models, again, despite their variety and regardless of the lens used, is the mostly unfettered access to personal and behavioral data that these companies have long enjoyed and capitalized on. The issue of data protection, or lack thereof, has thus become two sides of the same coin, at once the profit and cost centers within the digital marketplace. And so it is in this way that big tech has become gatekeepers of huge swaths of these data, and then they're therefore also able to boast of their free products and services. But given what we have learned just in this year, but especially over the years, I think we can all agree that these tools are far from cost-free for users, particularly for users of color, and that the more that tech benefits from data access, the more that us users are positioned as collateral. Data privacy protections for these reasons really is ground zero for addressing the harms associated with digital platforms and data-driven technologies. And I think that was another point that was really greatly highlighted by Professor Sweeney. By implementing usage restrictions and limitations in the absolute earliest stages of the tech development lifecycle, we can limit the abuses that are recycled and reinforced by automated technologies and the various products and services offered by tech platforms. For example, limits on data usage can impact how ranking and delivery algorithms are built in the development phase, so on the back end, but it can also curtail their discriminatory applications and deployment on the front end once deployed by third parties or tech platforms on their actual user interface. Finally, anti-discrimination protections for data privacy should really be considered a central feature of any sort of platform accountability and oversight agenda. As we continue to build a record of harms and better understand the various ways in which automated technologies compound and perpetuate racial, economic, and civil rights inequities, centering anti-discrimination protections in data privacy regulation can go far in addressing some of these far-reaching harms, and by providing an evergreen entry point for accountability and oversight, even as technologies continue to develop and novel uses do end up being devised. I'll go ahead and stop there and give it back over to Lindsay. Hopefully that was within time.
That was beautiful. Thank you so much. And let's go next to Karen, please.
Okay, I think you got me. Can you hear me? Okay, fantastic. I also am having some tech issues today. Cornell shut down its campus due to an Omicron outbreak. So I'm making do in a little closet in my house, but I'm really glad to be able to join you. I thought I would make a few comments about the use of data collection in an area where I've done a fair amount of research, which is labor in the workplace, particularly the low-wage workplace. So we certainly see kind of the disparate effects of data collection very acutely in the context of labor and work. I've done research in the context of several different kind of forms of work and types of workplaces. A lot of my work is focused on truck drivers. I've looked at retail workers and other folks whose work has really changed in nature due to increasing digital surveillance over them both by employers and by third parties who are interested in the data that they can glean from workers' behaviors. But it's also just increasingly the case for many of us, right? So, I mean, I'm a perfect example now, right? Many of us have worked from home are continuing to work from home in the context of the pandemic. And that very much blurs the boundary between work and not work, right? So some of you may be at home now, you're all getting to see a closet in my house, which is, you know, we could think of as being humanizing in some ways maybe, but we could also think of it as being more privacy invasive than it might otherwise be. And certainly for this panel, it's fine, you're all welcome to join me in my closet. But for many folks, right, what working from home has under that meaning is, you know, increased surveillance by coworkers, suddenly or by your boss, right? Suddenly your family, your kid, your dog, your bedroom is all on view. So it certainly starts to blur even further these boundaries between what we might think of as quite private spaces like the home and the workplace. And then even more consequentially, that blurring of that boundary drives employers to try to sort of regain control over workers via digital technology. So if you work in an office or in a warehouse or in some, you know, separate location, oftentimes there's a more kind of bounded, situated control that managers have over workers, which raise their own issues, right? But when the workplace is distributed, right, when folks do more of their work at home or in their own vehicles or using their own devices, we start to see employers worry that workers are like not working as hard as they might be, and that it's harder for them to control that than if the worker is at a more traditional workplace. So what we have seen, you know, in kind of the move to this hybridized workplace is the proliferation of many more data-driven metrics that are built into like everyday office software, different kinds of productivity scoring about what workers are doing, how many emails they're writing, which may or may not map onto meaningfully productive work, but we see this kind of effort to measure, right? This effort to collect more data about what people are doing. And this can have, you know, certainly the effect of locking down some channels where workers might communicate or organize or talk about how much money they're making or, you know, talk about workplace reforms. Like it certainly raises issues because of that, as well as just kind of, you know, kind of clamping down on workers and trying to eke, you know, little bits more productivity out of them. This stuff, to be clear, has been ramping up for a really long time. Like these are not new dynamics. But I think the pandemic has really turned up the volume on this. And what concerns me is that there's not kind of a natural off-ramp now, particularly if work sort of remains kind of hybridized into the future. Some of this has become, you know, really quite spectacular, right? We have seen the beginnings of much more, the normalization of much more invasive things like eye tracking and face recognition. These have been features of low-wage workplaces like Amazon warehouses or truck cabs for a long time, and they're now kind of starting to work their way up into other contexts of work, including professionalized work. There was a really excellent piece a few weeks ago in the Washington Post by Drew Harwell about contract attorneys who are required to use software that's constantly checking that they are like, you know, staring at their screens and that nobody else is in the room and that their eyes are on the thing and they're supposed to be looking at. And I expect we'll see a lot more of that sort of thing going forward. So I think where this all cashes out, or maybe a way to kind of understand all of these things, is that what we see is employers increasingly kind of trying to find ways to use data collection to shift more costs onto workers, right? So things that used to be kind of under the purview of the firm now become sort of the employer's problem to deal with, right? It's your problem if your face isn't legible, you know, to a productivity monitoring software. You know, it's your issue if, you know, the equipment that you have isn't sufficient to enable this kind of workplace tracking. So I'm really concerned about that the rise of workplace technology kind of means more residual cost and work for workers. And that always, you know, that doesn't mean that work has necessarily gotten more efficient. It just means that less powerful people are likely to bear more of that cost.
Thank you. That was terrifying and great. Let's turn now to Urmila, please.
Hi, y'all. Can you hear me? Okay, cool. I'm also having tech difficulties, just have to say that. But hi, everyone. Thanks again for having me. I'm Urmila Janardhan. I'm a policy analyst at Upturn. Upturn, as Lindsay said, is a DC-based nonprofit that focuses on advancing justice wherever technology is used. And although technology is a through line in our work, we tend to focus on issues that directly affect people's lives and opportunities like jobs, housing, the administration of public benefits, and the criminal legal system, amongst other things. So today I'm going to focus on the hiring process. I'm going to raise basically 3 points that apply across all of our issues. The first is that, and others have touched on this today for sure. The first is that historical and population data almost always reflect bias, which can lead to people getting rejected or excluded. The second is that all too often institutions rely on irrelevant data to make critical decisions about people. So this can look like criminal records or personality tests, which I'll get into. The third is that information asymmetries make it almost impossible for everyday people to identify when they've been discriminated against and then vindicate their legal rights. So before someone even applies to a job, it's important to note that commercial data flows affect who even learns what job opportunities are available. So in our ad discrimination work, we basically posted a bunch of job advertisements on Facebook. And with all other things being equal, we targeted all these advertisements in the same way. Facebook delivered our ads for jobs in the lumber industry to an audience that was 72% white and 90% men. Supermarket cashier positions went to an audience of 85% women, and jobs for taxi companies went to a 75% Black audience. So again, we didn't pick and choose or target these audiences, but Facebook's machine learning process using its own population data determined who would see each ad. And then beyond advertising, of course, the next step is what happens when people actually apply to a job. So in our most recent report, we applied to around 15 large hourly employers like Walmart, Starbucks, Walgreens. And so this work was grounded in a vision that all people should have access to work, and we wanted to focus in on where people might get unnecessarily excluded in this process, especially for hourly work, which can provide crucial income for people. So while there are a lot of new hiring technologies, what we found wasn't necessarily new or high tech. So the first thing that we noticed was it has never been easier for employers to screen out applicants through criminal records and background checks. So in every single employer we applied to, there was either an explicit question about criminal records or applicants were asked to agree to a background check should they be hired. And we know that Black people, Latinx people, people of color in general, are much more likely to be arrested and incarcerated and have those records follow them for years. The EEOC even acknowledges this disparate impact that criminal records can create. But again, it's difficult for people to know why they're rejected from jobs, so then difficult for any of those investigations to actually occur. The second thing we saw was that old school personality testing is alive and well online. The personality tests we saw asked questions that had almost nothing to do with the job. One asked applicants their level of agreement with this statement. Is it important to question authority? And another asked how much they agree with this statement. If I had to list everything I was grateful for, it would be a very long list. That question was from Amazon. CVS even had a set of questions where candidates pick between the two statements. I prefer a job where I have a stable and secure lifestyle, or I prefer a job where I'm held accountable for store outcomes. So going back to our vision, these personality questions are not good enough reasons to deny someone crucial income, and they can often uniquely discriminate against people with disabilities. So personality tests are actually normed in a similar way to machine learning algorithms. And if the norming populations who take these tests and determine, how it's graded, if these norming populations are white, middle class, and neurotypical, anyone who doesn't fit that norm will probably be scored worse. And I also want to note that personality tests have a long and well-documented history of being used to screen for anti-union sentiment as well. And you can read much more about that on our website. So these data flows, criminal records, background checks, personality tests, they're not new necessarily, but what is new is that it's never been easier for employers to implement them into their hiring process and then automate decisions based upon them. And it's never been less clear to applicants how they're being judged or why. Applicants rarely understand why they're rejected from jobs, and this gives them very little opportunity for recourse or to improve their applications for the next job. So these examples, of course, are all about hiring, but similar stories exist for people trying to get bail, get a loan, or get housing. And I'd really encourage folks to think about how people are concretely affected by technology and to focus on regulation or laws that address and reflect people's most urgent needs. And don't forget about traditional practices like, again, criminal records, personality tests, and things like that. Yeah, thank you.
Thank you so much. And I did not know that about the personality tests and anti-union sentiment. Very interesting. And Scott, please.
Great. Well, thank you so much to my fellow speakers for their insights, and to the NTIA, and particularly you, Lindsay, and Travis Hall for organizing this event and inviting me to participate. As the keynote speakers and my co-panelists have underscored in very context, data collection, sharing, and analysis imposes significant and disproportionate harms on marginalized communities, often trapping them in cycles of poverty, incarceration, and violence. But despite their vast reach and complexity, the judgments rendered by the systems are often highly reductive. You are your credit score, you are your criminal history, you are your zip code, you are your sex assigned at birth, all of which themselves are products of subordinating structures and history. But beyond these the disproportionate targeting and harms, even if surveillance were equally distributed, and again, it's not, marginalized communities are less able to absorb the social costs of any privacy violation, providing additional impetus for privacy protections. Compare, for example, and this may be an extreme example, but what happens when a privileged person like Hulk Hogan suffers what was undoubtedly a sexual privacy violation versus a parishioner who's outed by whose gay sexual orientation is outed by their pastor, or who a teenage woman of color is a victim of non-consensual revenge pornography. Hulk Hogan, of course, because of his social status and access to justice, is able to recover millions of dollars when outed by Gawker. The other two examples are not. They're not able to recover, and the harms that they do incur, even though they are also violations of sexual privacy, aren't valued to the same degree, even when they do receive judgments in their favor, which all militates, again, in favor of robust privacy protections in order to prevent these privacy harms from occurring on marginalized communities ex ante. Moreover, I want to underscore that, and this has come up both in Professor Sweeney's examples regarding failed facial recognition technology and how there are gaps, right, that women of color are not seen by the technology, and Professor Gilman's work, who spoke yesterday on surveillance gap. I want to provide another context where people are actually made more visible, okay, and their privacy is violated because they are not envisioned in the first instance. They're not seen as what they are, seen as people in the outset of a design decision. So, and these are sort of rudimentary examples, but I think they underscore how easy it is for people to be left out, which perhaps counterintuitively can lead to privacy violations. So data collection identity boxes often don't account for queer folk, trans folk, non-binary folk. They're literally left out of the data collection process or not seen in the data collection process. TSA screen, screening technology doesn't account for non-normative bodies, right? It presumes cisgender bodies. Bathrooms, which are also contexts of surveillance, are based on a normative binary. And what that means is that queer people are outed all the time, made more visible, and this forced visibility doesn't just mean that they may miss out on a service, but it also can lead to violence and danger and discrimination. So these harms that I've talked about and that others have been talking about are, of course, facilitated by practices. But I also think my final point I want to make is that they're also perpetuated by discourses, right? And Shoshana Zuboff, I think, she wasn't necessarily the first to talk about this, but I think does it in a really powerful way, in that she shows that the surveillance capitalists extraction processes are facilitated not just by the practices, but by ethos, false ethos, that help shape lawmakers' attitudes and society's attitudes about privacy. And the three of those ethoses are: one, that people don't care about privacy, okay, that it's dead in that it's inevitable and the cat's already out of the bag, and three, that it's all public information is protected by the First Amendment. These ethos are all false, okay? People do care. Marginalized communities have demonstrated that. They resist surveillance in myriad ways, as highlighted by organizations like Our Data Bodies and the Design Justice Network. Such resistance can be, really quotidian. That is simply shielding yourself from view, blocking cameras, moving your face away from view to really ultra forms of resistance. That is, facial recognition obfuscation technology, such as that developed by Hyphen Labs. So people do care. Marginalized communities are resisting surveillance. Moreover, privacy isn't dead. Just because information has been exposed in one context doesn't mean that it shouldn't be protected in another, and that shielding it in that context, in another context, isn't worth doing. Each act of either personal privacy resistance or, as it concerns the NTIA, privacy regulation raises the operating costs for data extraction companies and makes it harder to exploit the information at issue and creates less incentive to do so. That is, the privacy information is not zero sum. So yeah, you may not have perfect privacy, but even making it harder for the extraction to occur has in effect and deters the companies from exploiting that information. Finally, the last myth is that the First Amendment means that protects data companies and allows them to gather all this information that is, in their view, already exposed to the public. That's simply not true. And privacy actually is critical to First Amendment values and anti-subordination along a couple of dimensions. As Neil Richards and others have noted, it's key towards individual intellectual privacy, that is, developing our own thoughts for exchange in the public square. It's key to creating communities and leading to subaltern counter publics where further resistance and democratic ideas can emerge. And finally, as I've written about, privacy acts by marginalized groups to maintain their privacy are themselves expressive, performative examples of resistance, communicating to the government and corporations that they are not accepting the terms of engagement, that they resist the surveillance, and therefore, to the extent that these companies and the government start targeting people who care about their privacy, they are infringing on their expressive, performative privacy acts. I'll leave it there, but again, thank you to the NTIA and look forward to the Q&A.
Thank you so much, Scott. That was wonderful. And again, both parts wonderful and terrifying. So now we'll turn to our question portion of the panel. And Mila and Snigdha, maybe we could start with you. So the White House Office of Science and Technology Policy recently held a series of events on the intersection of artificial intelligence and equity. Privacy was a frequent topic. Could you speak a bit to how discussions of privacy overlap with conversations around equity, bias, and AI? And again, let's start with Urmila and then go to Snigdha and then open it up for the rest of the group.
Yeah, thank you for this question. I think privacy is a really kind of massive issue area. I feel like it concerns like the collection and use of data generally. So there is a lot of overlap with equity and bias issues. And I think a lot of equity and bias issues have a privacy angle and vice versa. So like just given some of the things I spoke about, like criminal records and hiring is an equity and bias issue, but then can also be seen as a privacy issue, like how records are accessed and how accessible they are to employers. And I haven't talked about our work related to policing today, but like facial recognition can be seen as like a criminal justice issue. It can be seen as a surveillance tool, and it's also a privacy issue. And we've advocated against the use of facial recognition, but I think also fits in this framework. So yeah, in short, the overlap is huge. I think the challenge is making sure that we're approaching privacy issues in a concrete and meaningful way and focusing on how people are actually affected.
Absolutely.
Thanks for the question, Lindsay, and thanks for your input, Urmila. So I think the audience, they might be surprised to hear me say that as far as AI or machine learning is concerned, privacy could almost be seen as a myth, because the conundrum is really that in order to have a less discriminatory or unbiased AI solution, model developers, they need access to personal information like age or sex, race, nationality, etc. And I'd almost like to use this as an opportunity to dispel the myth that protected class is only used in training and not in production. because many, if not all, underwriting and pricing models that are used specifically, I guess, in housing and lending, they are trained offline, and every decision that's made during training, it affects decisions that are made on live data. So saying something like, we only use protected class data, which is, personal information in training and not in production, is saying something like we trained our model, but we never deployed it, or something of that nature, which doesn't, really make sense. And there are even, examples and circumstances where using protected class information does result in fairer lending decisions. For example, the special purpose credit programs, the SPCPs, that are allowable under the Equal Credit Opportunity Act. They provide a more tailored way to meet special social needs and benefit economically disadvantaged groups, including groups that share a common characteristic, such as race, national origin, gender, etc. And when these SPCPs are properly designed, they can even play a critical role in promoting equity and inclusion, and building wealth, and really removing these stubborn barriers that have been there for so long and contributed to financial inequities in housing instability and residential segregation. And SPCPs are even consistent with and provide a targeted and effective way to further the purposes of other civil rights laws, including the Fair Housing Act's twin goal of overcoming discrimination and segregation.
Still getting used to the mouse pad on my work PC. Thank you so much. If anybody else wants to jump in, if not, we can move to the next question. All right. So algorithmic decision making certainly isn't the whole picture with regards to the ways in which commercial processing of personal data can affect equitable outcomes. Could you speak a bit to the potential disparate impacts that could occur through collection or sharing in addition to processing? Let's start with Karen and then Claudia, and then move to the larger group.
Thanks for asking that question, Lindsay. I feel like it's an especially important question to ask in the context of vulnerability, which I think all of the panelists have highlighted in one dimension or another. I think one thing that's quite useful for me in thinking about kind of using the lens of people's actual lived experiences to understand the harms of privacy, particularly around collection and sharing as opposed to merely processing, is like just how it becomes so much more acute, right? So there's like this old saw in privacy, which I think maybe comes from Ann Bartel, although I should have checked before the panel, but I think it's Ann Bartel that made this point, that privacy has what's sometimes called the dead body problem, right? That like one reason courts and legislatures have historically had kind of a difficult time recognizing privacy harms or redressing privacy harms is because of this kind of myth that like, well, there's not enough dead bodies. I mean, like, obviously that's said facetiously, right? That there aren't dead bodies, and that makes it difficult to really assess what goes wrong or what the harm is when someone's privacy is invaded, right? Like lack of privacy doesn't always mean people die, and it can be difficult to pin that down. And so like this kind of like a problem that has bedeviled privacy litigation and rulemaking, people kind of say like, well, this is like why people say privacy is dead. But like one thing that is like just abundantly clear, if we think about it for 2 seconds, or if you listen to anybody on this panel, is that like if you're not seeing dead bodies, it's because you're not looking in the right places, right? That the harms that result from all of the types of data collection across all of the domains that Scott talked about or that Armila talked about, you see plenty of literal dead bodies, right? And plenty of quite acute, physical harms, personal harms, economic harms. When someone's, location data collection makes it possible for their abuser to find them, right? Which is something that just happens, all too much. Or when people are subject to predatory lending and they lose their homes, right? Or people miss out on the opportunities for jobs, right? Or, people are put into kind of a false light because of the types of targeted ads, right, that Dr. Sweeney talked about. All of those things are dead body problems. And I feel like it just becomes clear how high the stakes are really across the board, across all these different kind of domains of life decision making when we start to kind of recenter our focus on vulnerable groups, which is why I'm really glad that you've convened this panel and drawn together these experts who I think are all focused on that type of harm.
Great. That was actually, I couldn't have said it better myself, so what I'll do is just kind of add on to what Karen said. And I actually really appreciate highlighting the fact that sometimes some of these harms, it's sort of like a Pandora's box effect. Like once it's out, you can't put it back in, but that doesn't mean that the harm isn't there just because it isn't immediately apparent. I think I'll pivot to something that's like, a very concrete harm that you can be identified. And that happens in sort of any sort of transaction and the sharing or selling of personal data and information between third parties. So on one example, we know that various social media platforms do sell personal behavioral data, including information that should otherwise be protected by certain anti-discrimination protections to third-party advertisers who are looking to target specific demographics. So what this allows advertisers themselves to maybe sell one product to a certain demographic or one product at a certain price compared to other demographics. And I think, as my panelists also highlighted, right, this practice has also become increasingly sophisticated, so that we are now because of the sheer breadth of data that these platforms do have, they are now able to sort of use targeted proxies to be able to identify certain target groups and protected classes, ranging from educational levels, zip code, and so on and so forth. Another really sort of like concrete harm that particularly impacts immigrant communities is the sale and transfer of personal data and information to law and immigration enforcement. There's a great article just last week in the Washington Post that highlighted the ways in which data brokers, for example, like Equifax, have collected huge personal data and then worked with credit reporting agencies to get that data and then turn around and sell that to ICE and CBP so that they can actually carry out some of their immigration enforcement practices. And so what this does is that it actually presents sort of like a Sophie's choice for immigrant and mixed status households who then have to put themselves at serious risk just in order to access the most basic and fundamental of human needs, like water, power, internet, and so on and so forth. Since it is because signing up for those utilities that, they are then forced to share this data, which then gets sold and it turns into a feedback loop. So this only adds to the already, momentous hurdles that are erected for immigrants and other communities of color in accessing, basic life-sustaining utilities. I would say, as was also mentioned earlier by my panelists, this practice also calls into question another historic practice that has disproportionately targeted communities of color, which is the over-surveillance and over-policing of minority communities. So you can see this in everything from carceral technologies to forms of biometric or geographic surveillance technologies, and the ways in which we're just kind of hyper-perpetuating legacy or centuries-long practices of biased policing. And if I could just point out one sort of extra or one sort of last concrete harm associated with what we kind of consider data privacy, I would really want to highlight the issue of transparency and the ways in which it tends to be framed as the other side of the coin of privacy. But the reality is that we know that a lot of tech platforms, especially big tech, tends to hoard and use massive troves of personal data in a host of ways that beyond what each of us have raised today that we cannot possibly know or understand. And I think that was something that was highlighted in sort of the Facebook whistleblower papers, was really the extent to which we really can't know the real harms perpetuated by lack of data privacy protections if we continue to fall prey to the black box mentality, right, around these technologies. And so I would just say that, it's worth asking that if platforms and these companies are so quick to share and sell data or are prone to privacy breaches, which have continued to rise year after year, then why do we continue to allow them to establish their own standards for privacy regulation? And I would say more importantly, why don't they allow members of Congress or researchers to look under their hoods and evaluate the data processing mechanisms that they do have when we already are aware of so many harms? And I also want to pick up something else that Professor Sweeney said at the top of this call, where she mentioned the ways in which the social contract is being impacted by technology. And I would argue that the exploitation and monetization of our individual information really goes to creating an inherently disproportional bargaining position between both users of platforms and platforms themselves. And then I think that's kind of in that feedback loop is where we get caught in this issue of, as Professor Sweeney said, right, technologists become policymakers and then policymakers are left trying to catch up and keep pace with technologists.
Absolutely. Thank you. So if it seems like nobody else is jumping in, I'm actually going to build off of what Karen was discussing in terms of harm. And I've also never heard that dead body formulation. It's incredibly apt. So one of the deeper and seemingly intractable debates in privacy has been on sort of the nature of harm and how to theorize it and quantify it. So I'm turning to Scott. Are there any particular instances in the research for your book and the research that led up to the book on privacy at the margins that stood out to you as aspects of this debate of kinds of harm, ways of formalizing harm that have been sort of under-discussed or should be receiving more focus than they have?
Yeah, well, I think that Karen and Claudia did a great job of underscoring the real concrete harms that can flow to members of marginalized community when their privacy is violated. I think that's a key part of the battle. I think I might take your question to talk about another kind of harm, which is what I view as both group and societal harms that come from pervasive surveillance. So undoubtedly people suffer concrete harms when their privacy is violated, but I think the lack of respect for privacy is also having a real negative impact on our democratic society. Surveillance and the forced outing of people, not allowing them to be visible on their own terms when they desire, inevitably pushes them from the public sphere, creating the appearance of a more homogenous public sphere, or at best creating extremely segregated public spheres, and not allowing for people to see each other in different communities, and not allowing for the cross-pollination of ideas. So I think that surveillance is not only perpetuating segregation as a key toolbox in perpetuating segregation along many different demographic characteristics, but it's also leading to isolation and a breakdown of discourse. And I think that's feeding the extremism we're seeing in our politics, is that people don't talk to each other anymore, because of, for example, the internet being used to abuse people of color, women, queer folk, right? They're not in the same internet space as the white patriarchal folk, and what that means is that the internet is not, as it was initially thought to be, this great bastion of democratic exchange. Instead, it's just a bunch of silos where radical is bred. And so I think that robust privacy protections, including those that the NTIA can help facilitate, is critical, not only to preventing the concrete individual harms that others have talked about, but really critical to helping our society get beyond the polarized state that we're in.
God, absolutely. If anybody else wants to jump in, well, then yes, I couldn't agree more. And the sort of side of, harassment and whom it disproportionately targets has an impact on the free speech rights of those people, I think is a side of sort of privacy versus free speech that we don't talk about enough. So thank you so much for highlighting that. I'm going to turn to some questions from the chat, starting with a question from Katerina Kopp, who is from the Center for Democracy and Technology. Could panelists discuss how data practices do not just reflect and perpetuate inequities, but that they exacerbate inequities? In other words, we're not just dealing with the same inequities in the digital space, but that digital data practices exacerbate and compound inequities. Great question.
I can take a stab at it if that.
Please.
I'll give it a shot.
That way.
It's a fantastic question. I think there's maybe a couple different things at play here, right? So one of them would be just the nature of AI as a kind of technology that's based on matching pattern, like that's built on, making predictions based on patterns that are in historical data, right? So many people have written, I think, really, really well. Dan Bauk is one person who comes especially to mind. Although it also appears in Scott's book, which is, I just happened to have on my desk. I promise that wasn't product placement that he paid me for. But one thing that really emerges is how much, decision making that's guided by historical data quite obviously carries forward, the state of the world that created that data to begin with. So a lot of people have raised this in the context of hiring as like a really obvious place, right? If a place never hired women before or hired women and treated them terribly, that will get reflected in the data that goes forward. So in that sense, there's an entrenchment that's just inherent to the technology. I also think there's another really strong point that Scott also brought up, kind of about the fact that the inequity arises both from visibility and from lack of visibility, which is a complicated thing, right? Because there's just not an easy answer there, right? And for everyone who says, oh, what we need is more accurate face recognition algorithms that like can really see you even better, there's someone else who says like, no, absolutely not, like that is the last thing we need. And both of those people are right? Like there's validity to the harms of both being erased by and being made visible by these systems. And so I think maybe that helps to create the sort of perpetuation or entrenchment of inequities that Katerina is talking about.
I can jump in really quickly. I think yes, everything Karen just said, and I think at least in hiring, a lot of what can happen is like discrimination at scale that's like very standardized. So instead of like an individual hiring manager at an individual Walmart coming up with a way to hire, it's like every Walmart in the country is hiring in exactly the same way. And so when an individual is screened out of one Walmart, they're never getting a job at any of them. And so like there have been examples of this in the news, but another thing is that like personality tests can also be similar across employers because there are a lot of similar vendors. So, and I'm sure this exists in like other types of decision making and other opportunities for people. So that's one thing to watch out for.
Absolutely. Now we have a question from Michelle Gilman, one of our wonderful panelists from yesterday. Great panel. Thank you, Michelle. And thank you to our panelists. Given the dead bodies and ample harms, can the panelists address why they think there isn't more public outrage and policymaking directed at these harms?
I'm happy to take a stab and then I can pass it on over to whoever. I think that there are kind of two answers to this question. And I think the first one starts with, again, going back to this idea that like for most consumers, a lot of these data-driven technologies are cost-free, right? We get various applications for free. We've been using various social media platforms for free. And often I think that the cost, like, I'm really reaching back to like Econ 101, but I'm pretty sure one of the first things we learn is this idea of opportunity cost. And I think the opportunity costs of using these different data-driven technologies and platforms is something that isn't totally felt by a large portion of the consumer base because of the ways in which these products do genuinely optimize or make more efficient our day-to-day activities. I think especially in the wake of COVID, I think that we've learned that, the internet and its various services and programs really serve as a lifeline, not only with each other, but even with daily life activities. So I think the more that these technologies have become ubiquitous and kind of assimilated into our daily life, the more we are willing to sort of overlook or kind of tone down some of the harms that we do know come with some of these. I would say that reality is sort of buttressed, sort of to my second point, by how little we really do know, right? And again, I think consumers are able to sort of downplay or kind of turn a blind eye to some of these larger harms because of how little really we do know. Again, to kind of go back to Frances Haugen and the Facebook papers, I think, again, that really underscored how little we really understand about the far-reaching harms and abuses that these technologies have, especially for communities of color. And so I think it's a combination of having to do a little bit of sort of public education for sure on the one hand, but I think on the other hand, there's a really big dimension in that, advocates, researchers, members of Congress themselves, policymakers really need to get a better understanding of really where the landmines lay and the outer bounds of which these harms, again, kind of perpetuate inequities or even create new ones and novel forms of them.
Absolutely. If nobody else wants to take that, then I will move to the last question in our chat from my colleague, Maureen Russell at NTIA and Office of Policy Analysis and Development. As tech companies are bought / sold / acquired by international entities, be it Meta, SoftBank, or state-owned entities, could the panelists reflect on potential harms to marginalized groups' privacy? Maybe concerns about authoritarian regimes that have different laws about data access and we also have a lot of brilliant domestic policy thinkers on this panel. So if this is not something that you've delved into deeply, we can always, take time, reflect, and move on to.
Yeah. I think with the, oh, sorry, go ahead, Scott.
Yeah, thanks for the question. I mean, I do think this is an area where, given the interconnected nature of data collection and analysis, where these sort of regional legal protections are going to start playing a bigger role because they can still influence and help regulate, and arguably they'll have even bigger impact the more consolidation there is. And so this, not to put too fine a point on it, like you can imagine the GDPR and CCPA doing some work here, but undoubtedly, to the extent that mergers and acquisitions help bring more data points together into giant conglomerates, that's going to amplify the power of these companies. One thing I was thinking about in response to the question, this isn't totally responsive, and there may be work done on this, but it would be really interesting to see, to analyze bankruptcy filings and see how much data repositories are being valued in bankruptcy auctions. So if a data company goes bottom up, like what are other companies willing to pay to come to swoop in and get that data? Much in the same way the companies, the IP, companies like Nokia, other sort of like in their intellectual property portfolios were highly valued. I can imagine the data portfolios also being highly valued, which I think could be another opportunity to shed light on what really matters to these companies. And again, maybe that work's already being done, but it was just a thought I had.
I don't know if it is, and someone should. I'll also add the other part of Maureen's question. Scott, I think you intuited the goal of the question better than I did with the first part of your answer. She added, or that only a few questions own the means to collect data. So that kind of consolidation, and yeah. On that note, thank you so much to our wonderful panelists. Also, thank you to my colleagues, Ruth Yudakin, Ryan Carroll, and our beloved MC Travis. This has been a really wonderful discussion, and I'm so glad that everyone on the panel has taken the time to be with us, not to mention the time preceding this panel. And thank you also to everyone dialed in or watching, and we just appreciate your time.
Thanks so much.
Excellent. Thank you.
Thank you.
And thank you to the panelists. You're welcome to stay on for the listening portion of the chat. I'll note that yesterday there were several questions that came up during the listening session portion that were more for the panel than for others, and there was kind of a general questions as well that some of the panelists were able to join in. So if you're able to do that, you're of course welcome to do so. So with now, we are turning the mic over to over to the public. I'm going to just reiterate some of the high-level ground rules. Again, my name is Travis Hall. I'm with the National Telecommunication and Information Administration with the Department of Commerce. These listening sessions are going to be taking place on Microsoft Teams. And while everyone is in attendee mode, we are going to be able to take you off of attendee mode if you are interested in speaking. The events are recorded and transcribed, and the recordings and transcriptions will be subsequently made available on NTIA's website. Live captioning is available through the Teams desktop, mobile, and web applications, but live captioning must be enabled by individual participants. And NTIA staff are monitoring the live chat, video, and audio, and we will remove participants who are attempting to disrupt the proceedings. Now, some additional stuff for the public participation portion of the website of the event. For the public participation portion, participants should use the raise hand function to indicate that they want to ask a question. If and when a participant is called on, NTI staff will temporarily enable the microphone for that participant to ask their question. Participants should note the name and affiliation as they ask their question, particularly because we have a lot of people who are calling in and are not able to see your name or that you've dialed in chat. For participants dialing in who wish to be called on during the portion of the event, please email me thall@ntia.gov, again thall@ntia.gov with the subject line listening session phone question. And please state your name and affiliation, and if possible, the gist of what question you'd like to ask. And importantly, we need to know what your phone number is so that we know who to call on. NTI staff will temporarily unmute you, and if you unmute yourself, then you will be removed from the call. Participants can also post questions in the chat, and just simply email me if you'd like me to read something out if you're feeling a little mic shy. And I'll just one more thing for folks who are dialing in, a nifty feature of Teams that I was not aware of until very recently is that you can actually hit *5 in order to raise your hand. So if you are dialing in and you would like to participate in the live portion, please feel free to hit *5. And so I have Lisa Klein, if you could raise your hand really quick. And Ryan, if you could get Lisa Klein teed up. And Lisa, you should be able to unmute yourself now.
Okay, hi. Here I am. Thank you very much, Travis and everybody. I learned so much listening in on this. My name is Lisa Klein, and I'm a parent living in Maryland, Montgomery County, Maryland. In the focus of today's session, being marginalized populations, I wanted to speak for a minute about a very particularly powerless group, and that is our kids, specifically school kids. So thanks to tens of thousands of educational technology products in our school, children's curiosities, successes, and failures are all bundled up and sold out the back door by so-called educational technology vendors. And this requires immediate attention. We need privacy promises from Edtech vendors. We need enforcement of FERPA, the Family Educational Rights and Privacy Act. And we need non-tech alternatives for families who want to totally opt out of this data mill. When my son was in 2nd grade, he came home with a Gmail address. The school forced him into this Google ecosystem without parental consent. Weeks later, I get a call from his teacher. She says, "Mrs. Klein, we are alarmed to see pictures of the Ku Klux Klan in your son's assignment about the environment." So we'd never talked about the KKK at home, and he didn't watch the nightly news at the age of 7 years old. So I asked his teachers to see the keyword search history, and he had typed in keywords "save the land," which happens to be part of the KKK's tagline. So he saw funny pictures of adults in costumes and figured that they were responsible for recycling in our communities. So I was relieved that it was kind of an innocent mistake. I was not at peace, however. So I contacted the chief technology officer and tried to get them removed from his file, only to realize that the minute he clicked on those images, they're gone. It's part of his profile that maybe colleges or employers would see later. So that's just one example of the exploitations of children at school, no less. With some other parents, I started the Student Data Privacy Project. We tried to access our kids' metadata using a FERPA access request. We were denied. The vendors pointed to the school pointed to the vendors. We enlisted over a dozen parents to do this across the country to test whether this really was not working. And in fact, nobody got the data that they asked for. Edtech is a Trojan horse, and there are a lot of analogies I can use, but I'll use one from my era, which is Joe Camel, who was the cool cigarette mascot. He lured the kids in, enticed them to smoke, and then made big bucks off of them. So it's time to shed the light on Edtech, Google specifically and unequivocally, who is cashing in on our kids off the backs of our schools. So thank you for listening, and I hope that you can include schools in the report that you create based on these sessions. Thanks, Travis.
Great, thank you so much. Ryan, if we could go to Emily next. Thank you. Emily, you can unmute yourself.
Good morning, everyone. Thank you for having me. My name is Emily Churkin. I have a master's in education. I was a classroom teacher for 12 years, and I'm a parent to 2 kids, 10 and 13. I'm also the screen time consultant. I've been featured in the New York Times, on the Today Show, and Good Morning America. In my various roles, I fight to better protect children from big tech. In addition to being an activist in my local school district here in Seattle, I'm also a co-founder of the Student Data Privacy Project, which we launched in 2020 to test the efficacy of federal laws that supposedly protect children's data. Spoiler alert, they don't. And children's data are being actively collected and exploited by technology companies without parental consent every day. Even before COVID, schools had been implementing all kinds of technology into the classroom. Remote learning added fuel to the fire. And what myself and other experts know is that distributing excessive technology in schools in the name of equity actually has the opposite effect. As an example, in Seattle, there's a lot of talk about prioritizing students who are, quote, furthest from educational justice. When COVID hit, Seattle Public Schools closed their doors and remained closed full time to its 50,000 students for 403 days. Meanwhile, private schools in our city reopened months earlier. How is this equitable for those students furthest from educational justice? Additionally, in spite of spending millions of dollars on tech for remote learning, the district purchased cheap, unreliable laptops for the 50,000 students. So parents who had the money purchased higher quality personal laptops for their children. The crappy district laptops were left for those students who couldn't afford another option, creating a stark have less setup. Some students simply were unable to participate due to tech issues. Finally, students who were left to learn on school laptops had to sign tech use agreements to participate in school. Students on private laptops did not. The consequences for the developmentally appropriate mistakes that might happen when students are given laptops and internet access were therefore different for 2 different groups of students, negatively impacting the very students the district claimed to prioritize. Additionally, collecting data about students who use district devices further worsens educational inequities. For our Student Data Privacy Project, we rounded up parent volunteers to submit FERPA requests to their child's school district. When districts did pseudo-comply with the request, and many did not, we found examples of children's data being collected without parental knowledge or consent. One child's parents received over 2,000 files, including videos of her young daughter doing yoga in her bedroom for her online PE class. As many of the experts today know, school districts have invested millions of dollars in technology platforms and apps in the name of education. Unfortunately, this high ticket price also comes with an increased risk of harm due to the loss of privacy and the misuse of collected data. Harms from the collection of our children's data are real and immediate. Just from applications in schools alone, big tech companies collect names, email addresses, addresses, attendance records, disability records, behavioral records, race, gender, ethnicity, grades, test scores, and much more. Students doing research on controversial topics, for example, may have these search histories saved and noted as indications of personal belief. Personality profiles created about children to predict their behavior are sometimes shared with local police departments. Additionally, children's preferences can be tracked and then used to market products and services to them or target them with messages to support eating disorders, misinformation, and violence. No adult today wishes we had a detailed record of everything we did, said, or wrote in middle school. It's a vulnerable, important time in a child's development when their identities are still forming. They need the support of teachers and parents to guide them, not the long arm or the deep pockets of the technology industry to manipulate them. Thank you.
Thank you so much, Emily. Ryan, if we could get Katie lined up, and then after that, Laura. Thank you. And Katie, you should be able to unmute yourself.
Thank you so much. I'm Katie Paul. I'm the director of the Tech Transparency Project. And the Tech Transparency Project urges the NTIA to investigate Google's role in broadcasting sensitive personal information that can be used in digital redlining. By default, Google shares users' personal information with more than 1,000 third-party companies every time that user visits a website or gets on an app that uses Google advertising services. Before Google displays an ad, the company's advertising auction platform broadcasts sensitive information about the user, including age, gender, interests, and precise location to every potential advertiser. This information can be used for discriminatory purposes, helping third parties determine a user's race, religion, sexual orientation, or other protected status, and target ads and opportunities based on that information. In 2020, the CEO of one data broker revealed that his company used this so-called bidstream data profile to profile Black Lives Matter participants and infer the user's religious affiliations. Google's own advertising tools can also be used to target ads in a discriminatory fashion. A 2015 academic study found that male users received more Google-served ads for high-paying jobs than female users with otherwise identical profiles. Federal regulators have taken action on these issues in the past. A 2019 Equal Employment Opportunity Commission judgment found Facebook guilty of facilitating similar employment-based discrimination through its advertising tools. With its massive troves of user data, Google allows unscrupulous data brokers and advertisers that might otherwise be unable to determine users' membership in a protected class to profile those users and target them in a discriminatory fashion. Any investigation into data brokers must begin with the surveillance companies that supply these brokers with Americans' personal information, including Google.
Thank you so much, Katie. Laura, Ryan, if you could make Laura a presenter. Laura, you should be able to unmute yourself. Thank you. Laura, if you're able to unmute yourself, there you go. Yep, we can hear you now.
All right, thank you very much. My name is Laura Darendinger. Thank you very much for giving me this opportunity. I'm a registered nurse with a background in public health. As a nurse, what I advocate for is best practices informed by independent, not industry-funded, peer-reviewed research. I also have 4 children, ages 12, 10, 8, and 6. It should not be a privilege to opt out of the harms from the digital product exposure that we've been discussing this afternoon. This panel is focused on privacy, how unfair and invasive data practices disproportionately harm marginalized groups with a focus on the range of harms. I will speak about harms related to children and exposure to invasive data practices that are relevant in the context of school from pre-K through 12th grade. The full range of harms incurred when children are required to use online and digital products for school include 1, harms to health, such as harms to mental health, impaired brain development, vision loss, hearing loss, excess weight gain, and pediatric obesity related to the sedentary nature of online and digital exposure. 2, decreased learning, despite effective marketing from companies that sell digital products to schools. Robust, independent data replicated to validate findings specifically shows immense harm to learning with regard to reading and writing skills, along with a delay to meet essential developmental milestones. And 3, the legal harms with the privacy violations, profiles that are created of children and follow them from kindergarten into the workforce, hence possibly limiting opportunities and the collection and monetization of children's and families' data. All of the above harms disproportionately affect marginalized children and communities, especially because it's happening in schools and classrooms where digital devices are now consistently present. Working parents must send their children to school. Who can opt out of the above harms? The only way to not have my own 4 children exposed to these harms is to remove them from school and homeschool them. I have read the independent, not industry-funded, peer-reviewed research, and there is nothing in the research, education, legal, or health, that suggests it's appropriate to expose children to online electronic products for recreation or purported education use. My children want to be in school with other children, and I would like to work as a public health nurse. We cannot do this right now because I'm forced to homeschool my children. Fortunately, we can live modestly on my husband's income for now. For low-income families, families where both parents must work, this is unfair that they have to have their children exposed to these harms of the online platforms. And it's especially egregious that while the children are forced to produce a product while in school, which some lawyers have suggested is a form of forced labor, the product is their data that's being collected. The children and families don't financially benefit, yet the companies that do collect and sell their data are reaping profits. Children and families are being forced to give up their data while at the same time they're being physically harmed, physically and mentally, by the online exposures that they're required to have in school. Every school where I have asked, if I enroll my 4 children in your school, may we please have a paper and pencil, non-digital option? The principal and superintendents have told me this is not possible. Fundamentally, when we speak about this topic, we must discuss how it's inappropriate to have these online data collections, products, and unfair invasive data practices in classroom settings. It harms all children and disproportionately harms children and families who don't have the choice to opt out. An immediate solution would be to create non-digital, pencil and paper book-based options for families. It would also be immediately appropriate to encourage policies that get children moving and learning outside during the school day. Research suggests time outside is effective to improve learning, improve physical and mental health. And time outside in good, healthy outdoor spaces need to be created now in marginalized communities, regardless of urban and rural settings. Green Schoolyards America is one group that over the past year during the pandemic focused on trying to create opportunities for outdoor learning in marginalized communities. It's fair if everyone can have the opportunity to follow best practices informed by independent research. Thank you.
Thank you. I'll take this opportunity as folks are thinking of their next comment or potential question to remind everyone that if you're interested in participating, please use the raise hand function. Or if you are on the phone, please email me at thall, THALL, @ntia.gov. With your name and affiliation, and most importantly, your phone number. Also, for those of you on the phone, you can put in a *5 and let us know that you are raising your hand and that you would like to participate. Let me just simply note that we've had a couple of different speakers now raise the issue of the potential harm of on children and that intersectionality with marginalized communities. We've also heard from some great keynotes from both Chair Urban and Professor Sweeney about some of the history and some of the current activities that are taking place on this, as well as a panel of experts on some of the other intersectionalities, be it employment or housing or sexuality, and the ways in which some of those, how commercial data flows can potentially affect that. I will put it out there that this panel is on the intersection of privacy and structural inequity, and we have not heard a lot yet about the ways in which the use of personal data by both companies, but also just simply in terms of commercial data flows, in terms of public partnerships, can be used to help alleviate structural inequity. We did hear briefly about some of that, but would be very interested and would love to hear some possible interventions there as well. And with that, I said this yesterday and I will say it again. A little bit of my background is that I was a college professor, and I have learned that in order to sometimes get people to participate, you have to get comfortable a little bit with some silence and let people think. So if no one has any questions or comments that they would like to raise right now, I'm still giving a little bit of time for folks to think about that and to intervene. And again, one of the things that we'd love to hear, if there are folks on the line who'd be interested in talking about some of the positive uses of personal data. We heard from the National Fair Housing Alliance that oftentimes data is required to be collected in order to ensure or check for discriminatory use. We would be very interested in hearing folks with that perspective. Also, of course, interested in hearing more on the subject of the ways in which structural inequities interplay with privacy. And perhaps as an additional prompt to the one that I just gave but hasn't gotten any takers, would be interested in hearing some possible thoughts on a question that was posed to the panel of, we've heard a lot about artificial intelligence. OSTP did a series of events a few weeks ago, specifically focused in on AI and algorithmic decision making, but the difference between their process and ours is we are looking at the collection of data, and we would be very interested in hearing additional thoughts about the role that data collection or data sharing or data processing could possibly play in these questions around equity and discrimination. Again, both positive and negative. We heard from Scott Skinner Thompson the idea that there is that there is both a need to be visible and a need to not be visible, right? That privacy is not just simply about being visible, but about proper data flow and the ability to be visible. So we would be very interested in any thoughts about the ways in which we're not just talking about artificial intelligence and potential bias in decision making, but also the collection of data itself. So if anyone has any interventions or thoughts that they would like to add there, both in terms of ways in which commercial data flows can recreate historical inequities, but then can also alleviate them. All right. So what we're going to do is I'm going to give it 1 more minute for anyone who has any questions, potentially for some of our panelists who might still be here, or potentially, some questions potentially for us. And would like to give one last opportunity for folks to raise examples real world examples of, again, either harm or positive uses of data. And if not, then I will go straight to some closing remarks, but I do want to give folks an opportunity to participate. All right, hearing none, that is fine. This is not the final opportunity by far to participate in these listening sessions. We have another one coming up tomorrow, and this one is really exciting. And that's focused, tomorrow's listening session is focused on solutions. So given the fact that we've talked a little bit about some of the deficiencies or gaps in current law, we've talked today about some of the harms that occur, some of the disparate impact that might occur, both through the collection, use, and sharing of data. We would be very interested in hearing what actually should then be done, and specifically what the administration can do to help move the ball forward in this area. And tomorrow we are honored to and very pleased to have our Deputy Secretary Don Graves giving keynote remarks. It'll be a slightly different format where the panel will come first. Another rockstar panel of experts from industry, academia, and civil society to discuss and lay the groundwork for possible solutions, and then followed again by a public listening session in which I am very excited to hopefully hear lots of folks chiming in with all of the ideas of what we actually can and should be doing. And so with that, I do want to thank Professor Sweeney and Chair Urban, and of course our panelists and my fellow organizers, Lindsay Barrett, Ryan Carroll, and Ruth Udakin for all of their hard work to make this happen. Thank you, everyone. We'll go ahead and give you a little bit of your time back.